may not be that great a lawyer, but choose out of their own option to practice at the district and overseas levels. If you do a good job of providing legal assistance to them, somebody has to provide legal assistance to them.
Your Lordship, just one point. Page 168 of my written submission, Your Lordship. Why the whole post enrollment is, Your Lordship, this is the first time when the bar exam question came into picture, and these are the recommendations of this committee headed by Mr. Gopal Subramaniam, along with the Bar Council of India chairman at that time, and also Mr. M.N. Krishnamani. 168 is a bar examination should be introduced for the purpose of admitting law graduates to the bar. As discussed, Supra, the introduction of a bar examination would ensure maintenance of standards in the legal profession, as well as standardization and constant innovation in the standards of curriculum teaching methodology. The committee is therefore of the opinion that qualifying a bar examination should be a requirement prior to the admission to the bar by all the state bar councils across the country.
That's the recommendation. Correct.
Yes, Your Lordship. Your Lordship, then specifically what I am talking about, Your Lordship.
Next slide.
Said introduced by introduction into the Advocates Act.
Yes, sir. Amendments.
Now you are wanting legislative amendments to bring it.
Yes.
We'll do a construction of the act as it exists today. We can't do legislative enactments. Not within our domain. If nothing has happened and this report has come, which is the year of the report?
Yeah, this is 2009 itself.
So 13 years has legislative enactment come. Persuade the parliament. Thank you.
Grateful, Your Lordship. Very grateful for your patience.
Thank you. Yes. Yes. What is your suggestion now, please tell us?
My lords, I am appearing in the writ petition number 25 of 2021.
Okay.
In the second matter.
Yes, please.
The petitioner is a law graduate.
Yes.
And he is from Mumbai High Court.
Maybe for me, come to the point.
Yes, my lord. This is the main point, my lord. But he is not able to pursue the practice.
Why is he not able to pursue? He is not able to clear the exam.
Because of my lord's COVID time, there was some problem. Now it is extended. But that is not my case. My case is, my lords, I just. Yes, my lord.
My lord, exam. In fact, it is too simple an exam. That's the problem with this exam.
Yes.
That is our trouble.
My suggestion is this, my lord.
If somebody is not able to make it, either he needs to strengthen his exam taking ability. Some people get maybe good, but get sometimes very sight with exams processes.
Yes.
Or possibly he needs to fine tune his skills to take the examination and academic notes. I'm sure you will help him.
Definitely, my lord. First day also I indicated it, and my lord.
I'm saying you will help that person.
Yes,
Nobody
this is the way, my lord, that will help me.
So you will help him how to take
Yes,
the exam.
my lord. My lord, my point is this, my lord. I will keep in my mind, my lord. That also. And my lord, what is my submission is this.
Yes.
Till today, from 1960 onwards,
Yes.
study reports, audits, judgments, nowhere saying about the post-enrollment exam.
It is talking about pre-enrollment exam?
Yes, we are supporting that.
No. Which of these talking about pre-enrollment exam? How many law schools are there of the countries which you take example of?
My lord, why I am saying this? Because today, my lord, constitution and irrespective of this case.
Yes.
So we are trying to make a suggestion or some mechanism to be implemented, which is according to us as per 1961 Act, Section 21 4D,
Yes.
24 1D.
Yes.
And my lord, for easy reference, my lord may come to the last page of my chart.
Yes.
That is in two color, blue color, then red color. It's for an easy reference, my lord.
Yes.
First column, my lord. First of all, section 24, that is for the easy understanding. Persons who may be admitted as advocates on state road. 1D, my lords are well aware. I don't want to repeat. Then, my lords, section 28. These have been gone, was going and coming back because of repeated acts. The first column, my lords, before 61, what was happening?
Yes.
Bombay and Calcutta High Court, attorneys and their law clerks and exam, etc. Well, 61 onwards, according to me, it's very serious. Respondent number, when I enacted the Advocates Act 1961, effective, my lords, in blue color, that blue color area, effect, which is I am supporting. So effect the act.
When you talk about 61 Act at that time, 61 to 70, the pre-enrollment exam was being held by whom?
Free and by bar councils. I got my lord question. We are not objecting or we are not saying
I'm just.
state bar council. That is the first two, section 24.
Exactly the distinction. That when the statute was amended, it was in a way to take away the powers of holding a state bar exams. Okay. There may be good, there would be, today we are talking about cute exam. Why? What to bring a uniform. Maybe at that time it was thought there was too lack of uniformity. What was being done. How people were aggrieved by whatever. Legislature in its wisdom thought it must go its way. They took away the power of the bar council.
Well, my answer is very clear, my lords.
Yes.
See, my lords, then if my lords, about this, what is this charge?
Yes.
2001-15,
Yes.
last column. After 61 remained in force, effect, the act prescribed pre-enrollment training and bar exams. Same time, respondent number 2 arbitrarily introduced AIB rules by with the post exam, a post enrollment exam. My lords, can this be done without following the act which is in force with the 2001 Act? That is what issued by them. That is what I challenge.
We do very simple. State power was abolished. Question is whether the Bar Council of India still has the power of it. Correct? To hold an exam once a person is enrolled. That is the question. Pre-enrollment you also hold. We have discussed at length here in your witness group. Problems exist in both scenarios. Pre-enrollment also has some scenarios. Post-enrollment has also some scenarios. Post-enrollment scenario as it exists today, we are endeavoring to fine-tune it in some way. Our council is also attending. Question is whether pre-enrollment can also be done. Yes, I don't think there is any difference of view that pre-enrollment exam can be done. Whether post-enrollment exam monitored as it is by the Supreme Court, would I not be the exam? The only thing.
My lords, I have a humble suggestion in that case, my lords.
Yes.
My lords saying whether it can be post or pre. My lords, if it is suppose my lord decide in that way, that post, because whatever your lordship's decision, it is a law of the land.
Yeah, we don't know. We may even leave
Yes,
it
my
to
lord.
our council to, we will check the validity of a system whereby whether a post-enrollment exam is feasible or not. Suppose we say post-enrollment is not feasible, then they can hold a pre-enrollment, we'll go back. If we come to the conclusion that Sudhir doesn't hold good law.
My lord, exactly that is my.
No, please, we've understood it.
No, my lord, sir, a little more, my lord. Exactly that is what my grievance. I came before my lord's court by way of this writ petition. My writ petition prayers are at page 17. It is challenged the ABE exam rules. My lord, sir, then suppose post enrollment exam for the time being, my lord, it is allowed or they are going to conduct or they are having the power 49AH. We are not objecting that. Bar Council of India is part and parcel of us. We are not saying that. But, my lords, after having or after enrollment, as my lord Justice managed to observe, section 2(1), section 30, I completed all the procedure. You have taken money from me. I am from a poor family. And I somehow managed money and enrolled. Now you are saying that you don't have any right.
I'm saying I will not clear the exam, but I will practice.
No, my lords. No, that is, my lords may kindly see the writ petition. What I am saying is, my lord.
This is the effect is this only. Somebody for bad indefinite reason doesn't clear the exam. Then he says scrap everything because I'm not able to clear.
No, that's not my.
I'm sorry.
My lords, kindly see my writ petition. What I am saying, pre-enrollment exam, there should have a mechanism. I'm fully with that.
If you can't clear a post enrollment exam, how would you clear a pre-enrollment exam? Is the difficulty level any less of that exam?
My lord.
It's a question of process or the statutory ability to carry it out. But difficulty level is not going to decrease, it's going to increase in terms of guidelines by us.
Well, my great.
So what will happen is now, you want some way or the other, you should get it. Not not possible.
My lord, my respectful submission
But
kindly.
we'll examine what your suggestion. Yes.
Yes,
You,
my lord. And my lord, from my written submission, one more point, my lord.
yes.
Only one more.
Last one, please.
But the subject to one can, sorry, subject to an order of observation, if my lords go through this, because of, I gone through some,
Why
more-
did you not go through it? You have given ideas from
because of my lords,
How?
because of four countries, 4-5 countries, they already conducting page 1. They are saying that it's a prerequisite. And all the study reports, orders, judgments saying that prerequisite. Parliamentary committee report is
Have
prerequisite.
you also specified how many lawyers practice in these countries?
My lords,
Asking you. Thank you.
that they have some mechanism, my lords. My lords, may kindly go through.
Thank you. Now, who are you for?
My lordship, I am for
I asked before lunch, who are left? 2 people stood up saying they have to argue.
My lordship, in fact, before I could come, in fact, because Mr. Karthik actually started arguing, so that's the reason I couldn't
Not shy.
mention.
See, we have to limit some time, right? We spend.
My lordship, I would not take more than, say, 3 to 5 minutes. Your Lordship.
Okay, tell us what you want to
No,
say.
like-
We have not listened till now.
Please, Your Lordship, let me not repeat. In fact, the learned amicus has covered actually most of the points that
Thank you.
I would want to argue, Your Lordship.
Thank you.
But let me start off with saying that I'm not averse to as far as the pre-examination is concerned. Now, if you have to actually trace the very genesis as to why this issue cropped up, was because looking into, let's say, the facilities of the college, where a 3-member committee was set up, where Mr. Gopal Subramanian, the chairman of the Bar Council, and the president of Supreme Court Bar Association.
Yes.
Bar Association. Now, the report that's been submitted by that committee relied upon the 184th Law Commission report, which had made a detailed study, a comparative study of UK, US, Singapore, which actually which suggested that there's a requirement for a pre-enrollment examination. Now, on the basis of that recommendation that is there, the same thing was actually followed in the report also. If your lordships were to see the conclusion of the report, which provides for a pre-enrollment examination itself, your lordships. My lordships, if your lordships were to have,
Report has suggested pre-enrollment.
please, your lordship. The reason as to why the pre-enrollment could not have taken place is because of, let's say, V. Sudhir, your lordships, because the embargo that was created by V. Sudhir.
So if we remove the embargo of Sudhir, then what happens?
My lordship, in fact, the easier way out would be, reading, section 149, 1 AG.
Every individual cannot see the easier way out. If we say Sudhir does not follow the law, then pre-enrollment is possible, correct?
Please, your lordships.
Question is whether post-enrollment is prohibited. Some of them have argued.
It would be prohibited. My submission would be that it would be
That
permitted.
has already been argued. If you
My
want to
lordship,
find
it would be violative of section 30, your lordships. In fact,
Will be argued.
under delegated legislation, there cannot, delegated.
something. Next.
My lordships, my lordships may have, section, 49, 1
I'm
AG.
saying if you have something new, please add. Nothing new and whatever has been urged, then repeating it by 3 councils will not strengthen it further.
I would only
Or
want
will
to,
reduce the efficacy of it either way.
I would only cement my argument saying that I'm in actual, in consensus as far as, the pre-enrollment is
Like
concerned.
everybody here is.
My lordships, in fact, the easier way without an amendment would be that, if your lordships were to actually, read section 49, 1 AG, which can be read into section 24, 1, your lordships, where the amendment also will not be required. My argument is that my lordships may have a section,
No, for pre or post you are saying now.
your lordships.
Pre, so there is no difficulty.
In fact, there's no amendment also that be required by the legislature, your lordships.
The issue is in a post case, some issue arose which Mr. Vishwanathan addressed. Then he slightly modulated his arguments in view of the debate which took place in the court. That's all.
Please, your lordships. My lordships may have a look at
When you-
section 30,
Okay, what did Mr. Vishwanathan say? You were here at that time, but
please, your lordships. My lordships, he did also,
you were not here.
please, your lordships.
Thank you. Next.
Only one sentence for him, my lords. My junior is saying, only for him. So then, one important point is there. Only
One for you,
sentence.
one for your junior, one for your second junior.
My lord, that training, whether it is post or pre, that training part may be concerned, my lord.
Training is not an issue.
Yes, grateful.
Thank you.
Much obliged, my lord.
Thank you very much for this.
Obliged.
Lord, your lordship. Lordship be pleased to lay down the order of address? We have three amicus and present here. I've already filed my brief. I'm happy to start.
And everybody
I leave it to your lordship.
so you may begin. What? Then you will be free. I think how much time will you take?
Me, my lord, since I put everything down in writing, I would like to go very fast with your
Then
permission.
you'll be
I
able to
don't want to take time over
I
it.
think then you'll be able to conclude today. So you start.
I beg my lord's pardon.
I said then you'll be able to conclude today. I said.
Most likely, if not,
Otherwise-
your lordship will
otherwise-
allow me to continue.
Yes. We are not prohibiting anybody.
Very well. My lord, I would prefer to address the second question first. Your lordship is aware that this reference has been made in two stages. The first was on powers under 142
Yeah.
to deal with a divorce by dispensing the period of in a mutual consent divorce or 18 months at the outer limit, whether under 142 a divorce can be granted. In my opinion, my lord, that's a relatively easy question to answer. But my lord, your lordship made a subsequent reference on the question whether irretrievable breakdown divorce can be granted, notwithstanding the fact that one of the parties is not consenting. So,
That
with,
we raised to see there are a number of cases coming up in court arising from such a scenario. Sometimes courts have exercised, sometimes they're not exercised. It arises at times when parties have been living apart for 15 years, 20 years. You know that there's nothing left in the marriage after
That's
so many years. Then should the court exercise 142 or not?
yes,
Or as we framed it, should we hedge the power under 142
yes,
by saying in no circumstance? Or we say, well, 142 power exists, or should be careful in doing so?
that's right.
There will be different degrees at which.
To that limited extent, below, there is an overlap between the two as to how does one look at 142.
Yes.
What are the powers? That is not very well covered ground.
Subjectivity also will arise from where it is.
Yes, my lord, that's a
That will
matter of
always arise.
discretion.
Then discretion will always, not even in this matter, otherwise also, it's bound to vary a little because we are,
Yes, my lord, from case to case.
we are not a composite court. We are a court of benches. So
Yes,
that's
and the conception of, at the end of the day, in the interest of justice, what is the conception of the court of justice? Now, my lord, that's why I said the second reference is more significant because the specific question raised there is when there is absence of consent by one side, then when can the court use its power under 142? Lord, I would like to carry the matter one step further with your permission, assuming the answer is yes, which in my opinion it is yes, whether even a trial court can do it in exercise of powers under section 151 of CRPC. So there are inherent powers in CPC. I'm sorry, CPC. Lord, all courts have inherent powers.
You are seeking to what we have been doing under 142. If I understand you correctly, I'm only phrasing to appreciate your submission. You are saying give powers to the High Court and Supreme
Yes.
Court also under 155. But
Yes.
the only, you may in your own way address it, the only impediment seems to be that despite recommendations of the law commissions, the disputable breakdown of marriage.
Yes.
The legislature has been reluctant.
Right, so both
So
parties.
we don't do 142 like just saying that we grant it. We say, okay, what is that you need? How do you need to maintain? So
Yes, Lord.
it's a balancing which we do.
It is, but my lord, I have, the way I have visualized it is, that, what is the public policy that governs the determination outcome? Now, my lord, it has always struck me as very strange that our matrimonial laws, they tell you what is the capacity to marry, what is the formality required for marriage, what is the way in which you can exit a marriage. But to the best of my knowledge, there are very few judgments which actually give us an idea of what exactly marriage is all about. Perhaps, my lord, it is incapable of definition. And that could be the reason why we don't find too many judgments. So, my lord, the way I've approached the issue is I begin by trying to explain with reference to case law how courts have visualized what a marriage ought to be. And then move on to the question that if that is not what the marriage consists of, as my lord put to me, is it dead? Is it an empty shell? Is it incapable of resolution? Then you reach the question, what now do we do after this? So, my lord, it's very, very important to address the question exactly what, under all laws, under all theories of justice, under all theories of matrimonial law, how does one conceive of the institution of marriage? So, my lord, if you turn to my amicus brief, I put it up. So, my lord, if your lordship turns to the second brief which I handed out today, definition of marriage and law governing marriages.
Yes.
Before answering the question as framed by this honorable court, it is necessary to point out the substance of marriage is a voluntary union that requires consent by both parties. Under some personal laws, the consent is given explicitly, and under other laws, implied. Now, my lord, on the review of the Hindu Marriage Act, I found that there is no specific provision saying that the two parties have to consent. It is only implied from the fact that both of them have to have the mental capacity to marry. Whereas in other laws, my lord, such as Islamic law, there has to be something called kabul, kabul, kabul. That means you're giving specific consent to the marriage.
It's a contractual marriage.
Yes. There is a specific requirement for consent in many laws, but in Hindu law, my lord, it is apparent to me that it's an implied consent because the capacity to marry includes the capacity to give consent.
Yes.
So, my lord, we'll proceed on the assumption that it's a voluntary union in which
The voluntary union, the fact that it's sacramental in character. So when you perform those essential ingredients of marriage, nobody can force you to take a saptamati, for example.
I presume so, my lord, but there is no specific provision in law
Yeah.
that the party has to give consent. My lord, I have personally dealt with cases where women have gone through Saath Feras. And my lord, one of my clients in this court, while she was doing the Saath Feras, she was sending messages to the police commissioner saying, I'm not consenting to this marriage. And my parents are forcing me into this marriage. I filed an Article 32 petition in this court saying, where is the consent? And it was just, my lord, settled by this honorable court by notice being issued to the parents. And they then agreed that, all right, if she files a petition for divorce, we'll not come in the way. Let the court decide. So, but be that as it may, my lord, let us proceed on the assumption that all marriage laws require consent. That is why I say it's a voluntary union between two people. Now, my lord, what are the implications flowing from this? We move to paragraph 3. All statutes with marriage and divorce, namely Special Marriages Act, Hindu Marriages Act, Divorce Act, Parsi Marriages Act, Dissolution of Marriages Act, Muslim Personal Law, Shariat Application Law, deal with capacity to marry, the procedure prescribed for formation of a marriage, and the manner and method of termination of marriage and divorce. However, strangely, none of them define what is marriage and or what happens during the subsistence of the marriage. Before dealing with the question of irretrievable breakdown of marriage, it is necessary to deal with what exactly is marriage. Now, in other countries, notably, Canterbury versus Canterbury, 1964 Australian law reports. Unfortunately, I was not able to access this judgment. I've taken it as reproduced in a judgment of the Delhi High Court, Arvinder Kaur versus Arvinder Singh. But your lordship may find a copy in the judge's library. I'm not sure whether this copy will be available, but this is what it says. Companionship, love, affection, comfort, mutual services, sexual intercourse, all these belong to the married state. Taken together, they make up consortium. Consortium has been defined as a partnership or association, but in the matrimonial sense, it implies much more than these rather cold words would suggest. It involves a sharing of two lives, a sharing of joys and sorrows of each party, or their successes and disappointments. In its fullest sense, it employs a companionship between each of them, entertainment of mutual friends, sexual intercourse, all these elements which, when combined, justify the whole common law dictum that a man and a wife are one person. Now, my lord, this.
That's fine.
As I said, this passage is quoted with approval. Just a minute, before I continue. If your lordship focuses on that last sentence, when combined justify the whole common law dictum, then a man and a wife are one person. But with respect, this last sentence requires to be dealt with great caution because it comes from the doctrine of coverture in common law, which in fact has been abolished. it belongs to a time when husband and wife could not sue each other, when the debts of one could be recovered from the other, when there were many disadvantages for a woman to be married because she was considered one person in the eye of law with her husband. She didn't have individual rights as an individual. So it has been done away in common law in many different situations, and I respectfully submit, my lord, after recognize the right to autonomy as a fundamental right. It certainly is not the law in India. This is about being one person. So, my lord, yes, a marriage is definitely an association under Indian law, which is monogamous in nature, but it doesn't follow that the two persons are one in the eye of law. That I wish to make very clear. Because if that was the case, my lord, there would be no doctrine of divorce at all. There would be no question of putting a marriage to an end with procedure prescribed by law. And my lord, so therefore, that one last sentence has to be taken with a bit of caution. My lord, incidentally, I've taken it from the judgment of the Delhi High Court in Harinder Kaur versus Harinder Singh. It was a judgment, my lord, which refused to strike down Section 9 of the Hindu Marriages Act on restitution of conjugal rights on the ground that it was unconstitutional. The learned judge held, my lord, that introducing constitutional law into the family was the famous phrase, my lord, quote unquote, introducing a bull into a china shop, close unquote. With great respect, my lord, I don't agree. But I must only tell you this, that the challenge to restitution of conjugal rights is also pending consideration in this court and was listed a few days earlier. So I will not get into that issue. For the moment, I'm just pointing out the source of this this court. Now, there's another court from a judgment of this court on how do we look at the institution of marriage. And that, my lord, comes from a recent judgment of this court, 2021, sought to define marriage as follows. A marriage is more than a seemingly simple union between two individuals. As a social institution, all marriages have legal, economic, cultural, and religious ramifications. The norms of a marriage and the varying degree of legitimacy it may acquire are dictated by factors such as marriage and divorce laws, prevailing social norms, religious diktats. Functionally, marriages are seen as a site for the propagation of social and cultural capital as they help in identifying kinship ties, regulating sexual behavior, and consolidating property and social prestige. Families are arranged of a mutual expectation. But I would like to emphasize this sentence. I believe one of my lords was a party to this decision. Families are arranged on the idea of mutual expectation and support and amity that is meant to be experienced and acknowledged amongst its members. Once the amity breaks apart, the results can be highly devastating and stigmatizing. The primary effects of such breakdown are felt especially by women who may find it hard to guarantee the same degree of social adjustment and support that they enjoyed while they were married. Well, this I rely on for two purposes. One, it gives a good description of what a marriage is meant to be. And two, what happens when that amity, expectation of amity is gone. Can you still continue to call it a marriage? That would be how I would address the question, my lord. And if you cannot, then what are the powers of the court to set the marriage legally asunder? Now, my lord, just one comment over here. And my lord, in law, marriage is generally considered a matter of status. And it is considered to be a status in rem rather than persona. Because, my lord, it is a declaration to the world at large that you are entitled to deal with this couple as a married couple. It's like a holding out doctrine. You hold yourself out as a man and wife, and you socialize together, etc. And then, as this court says, it has implications such as legitimacy of children, welfare of the children, and that is why it's considered a matter of status, not just a matter in persona. Similarly, a decree for divorce is also considered a matter of status. It again is a declaration to the world that I am no longer married to this person. So both are matters of persona, rem, and both a divorce decree is always considered a decree in rem. That is the status part of it. So, my lord, one of the sequiturs of this argument would be, why is it that a court of law has to give a decree for divorce? Why is it that I can't agree with my husband that you and I are divorced, and that's the end of it? Because it's a matter of status, because it's a decree in rem. And that is why, my lord, the power to grant a divorce is vested in a competent court of law. So the competent court of law will then look into all these other matters before pronouncing a decree for divorce, because it has ramifications for people beyond the two concerned. All this, my lord, I will link up with my argument that the court ought to grant a decree for irretrievable breakdown, because all the factors that are essential to a marriage have disappeared. They no longer exist. The only question is how to separate amicably. There is no other question for consideration. And of course, the other question for consideration is welfare, more particularly of the wife and the children. I am in strong disagreement with judgments of this court, which seem to indicate, and I believe that the union has filed an affidavit, not in this court, but in the restitution matter, saying that marriage is a sacrament, and it is the public policy of India that we don't break marriages. Well, it is the public policy of many countries in the world.
Two different things. Sacramental is how a marriage is made, maybe contractual and sacramental. Whether marriage can break or not is not in doubt with the divorce provisions being there in all the things.
Fine.
Now, the issue is that under the Hindu Marriage Act, the divorce is, the whole thing is based on a fault theory. That if you have a fault, you can't take advantage of that fault.
I understand. Section 23, subsection 1.
Irretrievable breakdown would have been a ground reality of the situation without getting into a blame theory.
Yes.
They look too good, and it's many cases we come before the court.
Yes.
Two where we have settled it, we have passed, sent to mediation, worked out a divorce. Two very good people may not be good partners. It's just one of those things. It's not necessary that sometimes we have come across cases where people have even lived together for a certain period of time. Then marriage breaks down. So being companion is different. Being married in the rigors of the marriage, how it works out are different systems.
Well, I understand that in order to answer this reference, one will have to get into the difference between fault theory of divorce and no fault theory of divorce, without any doubt. But, my lord, it's not such a black and white issue. The way I'm going to present it is there is an overlap between the two. And it's going to be my submission that every marriage where a petition for divorce is filed, and you know from experience, there are allegations and counter allegations. You have never seen a petition in which only one person alleges something and the other does not. There is always that claim and counterclaim by two sides. Then the question comes, are you going to look at the fault theory? Because section 23, subsection 1A specifically says that no party can take advantage of its own wrong. And the fault theory in Indian law is smuggled in through section 23A. No person can take advantage of their own wrong. And sometimes your lordships have used the expression, people who come to court must come with clean hands. That's the limited role of the fault theory. The fault theory has no role beyond that. That's my submission, my lord.
Also, to my mind, very subjective. What is the fault? See, somebody may say there are allegations made. She does not get up in the morning and give my parents tea. Is it a fault theory? Or somebody, you could have done the making of the tea better, maybe. Then, so, a lot of them are arising from a social norm. Social norm where you think that the lady must do this or the gent must do this. And from there we attribute faults. So this is another concern I have, that what we attribute as fault is not really a fault, but it's an understanding of a social norm, how a particular thing ought to be done.
Changing social. Changing social norms is very important.
very rapidly changing norm. Rapidly changing norm in terms of every couple of years this norm changes. That is the ground reality.
That is why this court has held that public policy is not frozen in time. Public policy, the West Bengal case, the West Bengal, I forget the exact cause title, but where the Henry VIII clause was challenged in this honorable court, which allowed for unilateral termination of a contract. And the question was, what is the constitutional validity of that unilateral termination law? There, the court has gone into the whole issue of public policy and held that public policy is not something static in point of time. Similarly, social norms are not static in point of time. Social norms change. It is no longer possible to argue a case of this kind or any matrimonial issue by relying on the laws of Manu. About that, my lord, I'm very clear. And therefore, my lord, arguments such as it's a sacrament, and therefore, we should not agree to this theory of irretrievable breakdown, do not make any legal sense, my lord.
That's in 1956 on once you, it was sacrament, always treated as sacrament. 1956 we introduced a divorce. Once you introduce a divorce, that in a sacramental marriage, divorce can take place is known. Question is, in that divorce proceeding, should somebody must be attributed a fault, or if two people can't live together, they go for a consent divorce, which was also introduced after some stage of time. Now the third scenario is which, well, you may think the other person is at fault. He can't somehow sit face to face with you and spend time with you. So if the court comes to an opinion that this marriage is not capable of any reconciliation, then there is no point in a actually pointless marriage, which is, as you say, the fundamentals of marriage are absent. And the only other thing is that what terms the marriage should take. You take in, protection and protect the women in whatever way. Sometimes women are actually better off than the men, so they don't even. We've seen cases where they agree that as long as this. I've seen cases where normally the women resist. The man was resisting. I said, "What's your problem?" She doesn't want anything. She has a better capacity to earn, a better position, but the man doesn't want to let go. I've exercised 142 even in those cases and granted saying that this is being obdurate unnecessarily. If people have not lived for a couple of years, it works now. Today works both ways.
Yes,
Right to resist.
because the law is gender neutral. The law itself is gender neutral.
Yes.
It will work both ways.
Can we carry on tomorrow?
Yes, and
Your Lordship, may I please have permission? Your Lordship, Mr. Dave has conveyed his apologies. Also,
The difference we have by for a amicus, I'm sure you can translate it to them.
please, Your Lordship.
Yes, Mr. Sibus. We'll see later. We are very hesitant on intervention because we don't want to.
I'm also hesitant.
Open floodgate of something. We are not allowing any intervention, but we will get your benefit of your submission. Since you have doctrine. Yes, violations of the case. The one containing the law commission reports. Most of them are not. All of us will be laying on almost the same thing. The third one is not what is left over.
we had quite
The short note, we have circulated the short note.
Some submissions have already.
Unfortunately, my submission but could not be. No, I'm not an amicus. I'm for one of the parties here representing.
You are one of the parties.
Yes, no.
Okay, we'll see what you
Petitioners in.
are.
Not, I am supporting the order. I'm saying that the order under 142 can be passed in cases where there is no consent
There was
also.
somebody who mentioned last time who was opposing it all.
I was not opposing, but I have some suggestions.
Whether the power under 142 should be inhibited at all.
That's
why the third question which your option said formulated is
That's most.
what is the approach to be?
That's the most.
Many cases are coming of that nature.
Correct.
To find a solution.
That's the most important issue.
And the question, if there is some submissions which Mr. Sibul wants to make as an amicus. Thank you.
Like-
Grateful to you.
Sorry, this one, not only my husband. So I will compare today with her. This is Manish. So he has given this. This is our. Then compare. We will make a list of what is not there and which is. He said that. Thank you.
We are not, therefore, we are not saying, it's not that the person who gets 80 marks practices in city, person who practices 70 marks practices there. It's a benchmark and you choose it. So there may be people who may not be, who have basic proficiency, may not be that great a lawyer, but choose out of their own option to practice at the district and Gosa levels. If you do a good job of providing legal assistance to them, somebody has to provide legal assistance to them.
Your Lordship, just one point. Page 168 of my written submission, Your Lordship. Why the whole post enrollment is, Your Lordship, this is the first time when the bar exam question came into picture, and these are the recommendations of this committee headed by Mr. Gopal Subramaniam, along with the Bar Council of India chairman at that time, and also Mr. M.N. Krishnamani. 168 is a bar examination should be introduced for the purpose of admitting law graduates to the bar. As discussed, Supra, the introduction of a bar examination would ensure maintenance of standards in the legal profession, as well as standardization and constant innovation in the standards of curriculum teaching methodology. The committee is therefore of the opinion that qualifying a bar examination should be a requirement prior to the admission to the bar by all the state bar councils across the country.
That's the recommendation, correct?
Yes, Your Lordship. Your Lordship, then specifically what I am talking about, Your Lordship.
Next slide.
It said introduced by introduction into the Advocates Act.
Yes, sir. Amendments.
Now you are wanting legislative amendments to bring it.
Yes.
We'll do a construction of the act as it exists today. We can't do legislative enactments.
I understand.
Not within our domain. If nothing has happened and this report has come, which is the year of the report?
Yeah, this is 2009 itself.
So 13 years has legislative enactment come. Persuade the parliament. Thank you.
Grateful, Your Lordship. Very grateful for your patience.
Thank you. Yes. Yes. What is your suggestion, please tell us?
My lords, I am appearing in the writ petition number 25 of 2021.
Well,
In the second matter,
yes, please.
the petitioner is a law graduate
Yes.
and he is from Mumbai High Court.
Maybe for me, come to the point.
Yes, my lord. This is the main point, my lord. But he is not able to pursue the practice.
Why is he not able to pursue? He is not able to clear the exam.
Because of my lord's COVID time, there was some problem. Now it is extended. But that is not my case. My case is, my lord, I just, yes, my lord. My lord,
It's a difficult exam. In fact, it is too simple an exam. That's the problem with this exam.
Yes.
That is our trouble.
My suggestion is this, my lord.
If somebody is not able to make it, either he needs to strengthen his exam taking ability. Some people get maybe good, but get sometimes very cyclical exams processes.
Yes.
Or possibly he needs to fine tune his skills in the examination and academic notes. I'm sure you will help him.
Definitely, my lord. First day also I indicated it, and my
No,
lord.
I'm saying you will help that person.
Yes,
Nobody
this is the way, my lord, that will help me.
So you will help him how to take the
Yes,
exam.
my lord. My lord, my point is this, my lord. I will keep in my mind, my lord. That also. And my lord, what is my submission is this.
Yes.
Till today, from 1960 onwards,
Yes.
study reports, audits, judgments, nowhere saying about the post-enrollment exam.
It is talking about pre-enrollment exam?
Yes, we are supporting that.
No. Which of these talking about pre-enrollment exam? How many law schools are there of the countries which you take example of?
My lord, why I am saying this? Because today, my lord, constitution and irrespective of this case.
Yes.
So we are trying to make a suggestion or some mechanism to be implemented, which is according to us as per 1961 Act, Section 21 or D,
Yes.
24 1D.
Yes.
And my lords, go easy reference, my lord may come to the last page of my chart.
Yes.
That is in two color. Blue color, then red color. It's for an easy reference, my lord. First column, my lord. First of all, section 24, that is for the easy understanding. Persons who may be admitted as advocates on state road. 1D, my lords are well aware. I don't want to repeat. Then, my lords, section 28. This has been gone, was going and coming back because of repeated acts. The first column, my lords, before 61, what was happening?
Yeah.
Bombay and Calcutta High Court, attorneys and law clerks and exam, etc. Well, 61 onwards, according to me, it's very serious. Respondent number, when I enacted the Advocates Act 1961, effect, my lords, in blue color, that blue color area, effect, which is I am supporting. So, effect the act.
When you talk about 61 Act at that time, 61 to 2050, the pre-enrollment exam was being held by whom?
Free and by bar councils. I got my lord's question. We are not objecting, or we are not saying.
I'm just.
State bar council. That is the first two, section 24.
Exactly the distinction. That when the statute was amended, it was in a way to take away the powers of holding a state bar exams. Okay. Then maybe good, there would be, today we are talking about QT exam. Why? What very uniform. Maybe at that time it was thought there was too lack of uniformity. What was being done, how people were aggrieved by whatever students. The legislature, in its wisdom, thought it must go its way. They took away the power of the bar council.
Well, my answer is very clear, my lords.
Yes.
See, my lords, then if my lords, what is this charge?
Yes.
2001-15,
Yes.
last column. After 61 remained in force, effect, the act prescribed pre-enrollment training and bar exams. Same time, respondent number 2 arbitrarily introduced AIB rules with the post exam, a post enrollment exam. My lords, can this be done without following the act which is in force with the 2001 Act? That is what issued by them. That is what I challenge.
We do very simple. State power was abolished. Question is whether the Bar Council of India still has the power of it. Correct? To hold an exam once a person is enrolled. That is the question. Pre-enrollment you also hold. We have discussed at length here in your witness group. Problems exist in both scenarios. Pre-enrollment also has some scenarios. Post-enrollment has also some scenarios. Post-enrollment scenario as it exists today, we are endeavoring to fine-tune it in some way. Our council is also attending. Question is whether pre-enrollment can also be done. Yes, I don't think there is any difference of view that pre-enrollment exam can be done. Whether post-enrollment exam monitored as it is by the Supreme Court, would I not be able to the only thing.
My lords, I have a humble suggestion in that case, my lords.
Yes.
My lords, saying whether it can be post or pre. My lords, if it is supposed, my lord decided in that way that post, because whatever your lordship's decision, it is the law of the land.
We don't know. We may even leave
Yes,
it
my
to
lord.
council to, we will check the validity of a system whereby whether a post-enrollment exam is feasible or not. Suppose we say post-enrollment is not feasible, then they can hold a pre-enrollment, we'll go back. If we come to the conclusion that Sudhir doesn't hold good law.
My lord, exactly that is my.
Please, we've understood it.
No, my lord, sir, a little more, my lord. Exactly that is what my grievance. I came before my lord's court by way of this writ petition. My writ petition prayers are at page 17. It is challenged the ABE exam rules. My lord, sir, then suppose post enrollment exam for the time being, my lord, it is allowed or they are going to conduct or they are having the power 49AH. We are not objecting that. Bar Council of India, Part and Parcel of us. We are not saying that. But my lords, after having or after enrollment, as my lord Justice managed to observe, Section 2(1), Section 30, I completed all the procedure. You have taken money from me. I am from a poor family. And I somehow managed money and enrolled. Now you are saying that you don't have any
I'm
right.
saying I will not clear the exam, but I will practice.
No, my lords. No, that is, my lords may kindly see the repetition. What I am saying is, my lord,
This is the effect is this only. Somebody for bad indefinite reason doesn't clear the exam, then he says scrap everything because I'm not able to clear.
no, that's not my,
I'm sorry.
my lords, kindly see my repetition. What I am saying, pre-enrollment exam, there should have a mechanism. I'm fully with that.
If you can't clear a post enrollment exam, how would you clear a pre-enrollment exam? Is the difficulty level any less of that exam?
My lord,
It's a question of process or the statutory ability to carry it out. But difficulty level is not going to decrease, it's going to increase in terms of guidelines by us.
my lord, my
So
great.
what will happen is now, you want somewhere or the other, you should get it. Not possible.
My lord, my respectful submission
But we'll
kindly.
examine what your suggestion. Yes.
Yes,
You,
and my lord, from my written submission, one more point, my lord.
yes.
Only one more.
Last one. Yes.
But the subject to one, sorry, subject to no, observation, if my lords go through this, because of, I gone through some of,
Why
for
did you not go through it? You have given ideas from
because of my lords,
How?
because of four countries, 4-5 countries, they already conducting page 1. They are saying that it's a prerequisite. And all the study reports, orders, judgments saying that prerequisite. Parliamentary committee report is
Have you
prerequisite.
also specified how many lawyers practice in these countries?
My lords,
Asking you. Thank you.
that they have some mechanism, my lords. My lords, may kindly go through.
Thank you. Now, who are you for?
My Lordship, I am for
I asked before lunch, who are left, 2 people stood up saying they have to argue.
My Lordship, in fact, before I could come, in fact, because Mr. Karthik actually started arguing, so that's the reason I couldn't
Not
mention
shy.
it.
See, we have to limit some time, right? We spent.
My Lordship, I would not take more than, say, 3 to 5 minutes. Your Lordship.
Okay, tell us what you want to.
My Lordship,
We have not listened till now.
Please, Your Lordship, let me not repeat. In fact, the learned amicus has covered actually most of the points that
Thank you.
I would want to argue, Your Lordship.
Thank you.
First, let me start off with saying that I'm not averse to as far as the pre-examination is concerned. Now, if you have to actually trace the very genesis as to why this issue cropped up, was because looking into, let's say, the facilities of the college, where a 3-member committee was set up, where Mr. Gopal Subramanian, the chairman of the Bar Council, and the president of Supreme Court Bar Association. Now, the report that's been submitted by that committee relied upon the 184th Law Commission report, which had made a detailed study, a comparative study of UK, US, Singapore, which actually which suggested that there's a requirement for a pre-enrollment examination. Now, on the basis of that recommendation that is there, the same thing was actually followed in the report also. If your Lordships were to see the conclusion of the report, which provides for a pre-enrollment examination itself, your Lordships. My Lordships, if your Lordships were to have,
Report has suggested pre-enrollment. No.
please, your Lordship. The reason as to why the pre-enrollment could not have taken place is because of, V. Sudhir, your Lordships, because the embargo that was created by V. Sudhir.
So if we remove the embargo of Sudhir, then what happens?
My Lordship, in fact, the easier way out would be, reading, section 49(1) AG.
Every individual cannot see the easier way out. If we say Sudhir does not follow the law, then pre-enrollment is possible, correct?
Please, your Lordships.
Question is whether post-enrollment is prohibited. Some of them have argued.
It would be prohibited. My submission would be that it would be
That
permitted.
has already been argued. If you
My
want to
Lordship,
find
it would be violative of section 30, your Lordships. In fact,
Will be argued.
under delegated legislation, there cannot, delegated,
something- Next.
my Lordships, my Lordships may have, section, 49(1)
I'm
AG.
saying if you have something new, please add. Nothing new and whatever has been urged, then repeating it by 3 councils will not strengthen it further.
I would only
Or
want
will
to,
reduce the efficacy of it either way.
I would only cement my argument saying that I'm in actual, in consensus as far as, the pre-enrollment is
That
concerned.
everybody here is.
My Lordships, in fact, the easier way without an amendment would be that, if your Lordships were to actually, read section 49(1) AG, which can be read into section 24(1), your Lordships, where the amendment also will not be required. My argument is that my Lordships may have a section,
No, for pre or post you are saying now.
your Lordships.
Pre, so there is no difficulty.
In fact, there's no amendment also that be required by the legislature, Your Lordship.
The issue is in a post case, some issue arose which Mr. Vishwanathan addressed. Then he slightly modulated his arguments in view of the debate which took place in the court. That's all.
Please, Your Lordship. My Lordships may have a look at
When you-
section 30,
Okay, what did Mr. Vishwanathan say? You were here at that time.
please, Your Lordships. My Lordships, he did also.
You were not here.
Please, Lordship.
Thank you. Next.
Only one sentence for him, my lords. My junior is saying, only for him. So then, one important point is there. Only
One for you,
sentence.
one for your junior, one for your second junior.
My lord, that training, whether it is post or pre, that training part may be concerned, my lord.
Training is not an issue.
Yes, grateful.
Thank you.
Much obliged, my lord.
Thank you very much for assisting.
Obliged.
Lord, your lordship be pleased to lay down the order of address. We have three amicus and present here. I've already filed my brief. I'm happy to start.
Everybody
I leave it to your lordship.
so you may begin. What? Then you will be free. I think, how much time will you take?
Me, my lord, since I put everything down in writing, I would like to go very fast with your
Then
permission.
you'll be
I
able to
don't want to take time over
I think
it.
then you'll be able to conclude today, so you start.
I beg my lord's pardon.
I said, then you'll be able to conclude today, I said.
Most likely, if not,
Otherwise-
your lordship will
otherwise-
allow me to continue.
Yes, we are not prohibiting anybody.
Very well. My lord, I would prefer to address the second question first. Your lordship is aware that this reference has been made in two stages. The first was on powers under 142
Yeah.
to deal with a divorce by dispensing the period of in a mutual consent divorce or 18 months at the outer limit, whether under 142 a divorce can be granted. In my opinion, my lord, that's a relatively easy question to answer. But, my lord, your lordship made a subsequent reference on the question whether irretrievable breakdown divorce can be granted, notwithstanding the fact that one of the parties is not consenting. So,
That
with,
we raised, to see, there are a number of cases coming up. What arising from such a scenario. Sometimes courts have exercised, sometimes they're not exercised. It arises at times when parties have been living apart for 15 years, 20 years. You know that there's nothing left in the marriage after
That's
so many years. Then should the court exercise 142 or not?
yes,
Or as we framed it, should we hedge the power under 142
yes,
by saying in no circumstance? Or we say, well, 142 power exists, but should be careful in doing so.
that's right.
There will be different degrees at which.
To that limited extent, below, there is an overlap between the two as to how does one look at 142.
Yes.
What are the powers? That is not very well covered ground.
Subjectivity also will arise from where it is.
Yes, Lord, that's a matter of discretion.
Then discretion will always, not even in this matter, otherwise also, it's bound to vary a little because we are.
Yes, Lord, from case to case.
We are not a composite court. We are a court of benches. So
Yes, and the conception of, at the end of the day, in the interest of justice, what is the conception of the court of justice? Now, my Lord, that's why I said the second reference is more significant, because the specific question raised there is where there is absence of consent by one side, then when can the court use its power under 142? Lord, I would like to carry the matter one step further with your permission, assuming the answer is yes, which in my opinion it is yes, whether even a trial court can do it in exercise of powers under section 151 of CRPC. So there are inherent powers in CPC. Lord, all courts have inherent powers.
You are seeking to what we have been doing under 142. If I understand you correctly, I'm only phrasing to appreciate your submission. You are saying give powers to the High Court and Supreme
Yes.
Court also under 155.
Yes.
The only, you may in your own way address it, the only impediment seems to be that despite recommendations of the law commissions, to irretrievable breakdown of marriage.
Yes.
The legislature has been reluctant.
Right, so